This presentation discusses HIPAA compliance for small organizations. Together with software from ACR and support from Compliance Helper, these videos describe a comprehensive program for HIPAA compliance for small organizations. ACR2 has created a systematic web-based method for helping small organizations achieve full HIPAA compliance at a minimum of cost and effort. The software uses the standards published by the National Institute of Standards and Technology, as recommended by the HIPAA auditors of the Office of Civil Rights. The step-by-step program provides a cost-effective alternative to scarce and expensive consultants typically used by hospitals and large practices. Creditworthy small organizations can lease all the hardware and software necessary for effective program management for as little as $149 a month. The package includes risk assessment software, policy creation and maintenance, and customized employee training. This compares favorably to thousands of dollars for a one-time consultant. There are currently 5 videos in this series, with others planned to follow. Risk under the Health Insurance Portability and Accountability Act, or HIPAA, has a very specific legal meaning. Risk to a protected health information asset is the net negative impact of the exercise of a vulnerability by a threat source, considering both the probability and the impact of occurrence. Managing risk under HIPAA is done by identifying risk, assessing risk, and then implementing safeguards to limit risk to acceptable levels. Zero risk is not possible. Acceptable risk, as defined by the federal government, is highly possible. It does require systematic effort and is unlikely to happen by chance. Risk management begins with identifying and assessing risks to information assets. The Office of Civil Rights is responsible for issuing guidance on HIPAA security rule requirements. Risk assessment is referred to by OCR as the foundational step in HIPAA risk management. Every organization handling protected medical information, whether it is a covered entity providing medical services or business associate supporting a covered entity, must do a HIPAA-compliant risk assessment every year. It should be noted that a large percentage of medical information breaches to date have been committed by business associates. Prior to 2013, business associates were not required to do a risk assessment, and covered entities were not liable for breaches by business associates. Both of those items changed in 2013. Business associates and covered entities must both do HIPAA-compliant risk assessments. Covered entities must then confirm business associate compliance before granting the business associate access to protected information. A business associate is now defined as any organization that creates, receives, maintains, or transmits protected health information on behalf of a covered entity. A covered entity can be a business associate of another covered entity. A major industry problem is the attempts by many business associates to avoid their new obligations under the 2013 HIPAA changes. An example of a business associate breach is the release of over 600,000 WellPoint records by a network contractor. It cost WellPoint well over $1 million in fines and fees. To date, the lack of a HIPAA-compliant risk assessment is the #1 cause of organizations failing HIPAA audits. OCR estimated in September that 66% of clinics had still not done any risk assessment. Compliance is even worse among business associates. There are 9 basic steps in a risk assessment designed to meet OCR requirements under HIPAA. These requirements originated with NIST Special Publication 800-30. All steps are required. Any risk assessment protocol that includes all of the 9 steps will meet HIPAA requirements. However, page 1 of the OCR Risk Assessment Guidance refers to the guidelines of the National Institute of Standards and Technology as the industry standard for protecting health information. If you choose an alternative to the NIST protocols, it is important to meet all of the 9 requirements. There's a lot of fraudulent advice out there, some unfortunately from academic or even from official sources. For example, ONC points out very explicitly on page 11 of their security guide that a checklist cannot be substituted for a risk assessment. Checklist fails to complete steps 5, 6, and 7 of the 9-point requirements. Such an attempt, while popular, is unlikely to pass an audit. It is unwise to count on any protocol that includes a disclaimer. For example, the currently available Security Risk Assessment Tool checklist with 156 questions is the best ONC checklist so far. It is significantly more user-friendly than the NIST equivalent. However, it is not a risk assessment and does not claim to be a risk assessment. The Risk Assessment Tool aggressively states that it is for information purposes only. Checklists can be useful, absolutely, but they are not a substitute for a real risk assessment. If you are being advised to use a checklist in place of a real 9-point risk assessment, you should get an explicit, ironclad guarantee in writing and have it reviewed by your attorney. If you accept bad advice from any source, you are still liable. Given that the HIPAA auditors are required by law to use the NIST protocols internally, there are serious advantages to using the NIST approach over otherwise acceptable 9-point alternatives such as COBIT or ISO. A disadvantage is that the protocols needed to complete an NIST risk assessment are voluminous and less than user-friendly. They are, however, very well written and frequently updated. They do require significant expertise to use directly. The ACR computerized version of the NIST protocols provides a TurboTax-style interface that greatly simplifies HIPAA compliance while maintaining the utility of the NIST protocols. Following identification and assessment of risks, covered entities and business associates must control risks by maintaining reasonable and appropriate safeguards. Once safeguards are in place, they must be periodically reviewed, modified, and documented. The HIPAA security rule does not specify which safeguards are reasonable and appropriate for which size of organization. This compliance program is based on NIST 800-66, an introductory guide to HIPAA security rule compliance. There are 101 HIPAA safeguards under NIST 800-66. However, not all safeguards are reasonable and appropriate for all organizations. Reasonable and appropriate depends on the size and resources of the organization. The updated HIPAA security rule explicitly states that covered entities and business associates have the flexibility to choose security measures appropriate for their size, resources, and the nature of the security risks they face. Reviewing small organization safeguards, we begin with the 101 HIPAA safeguards that are present under NIST 800-66. More than 40 of these 101 safeguards may be considered not appropriate for very small organizations. Around 40 safeguards are moderately complex and may be implemented using a short policy or procedural document. Approximately 18 of these safeguards are typically outsourced to IT or legal professionals. This leaves only 4 major safeguards that will take significant effort and may involve consultants. Getting started with automated HIPAA security rule compliance is relatively straightforward. HIPAA security rule compliance using the NIST standards is a cyclical process. The overall cycle of 11 tests is shown here. For convenience, the more or less annual cycle has been divided into 4 quarters. A given set of tasks may take more or less time than this, depending on the complexity of the situation and available resources. Begin by reviewing the HIPAA overview video. This will describe an overview of the HIPAA compliance process for small organizations. Next, view the video discussing the safeguards that may not be reasonable and appropriate for a small site. The client will then be able to fill out the NA Safeguards status form. Note that only the client will have the site-specific information needed to fill out this form on which safeguards are not appropriate. Using the information from the client's site-specific NA form, ACER 2 will generate the initial risk assessment for the site. Filling out the NA status form will typically take less than 4 hours and is likely to generate a risk chart similar to that shown. In this risk chart, red stands for high risks that need to be remediated as soon as possible. Moderate or yellow risks should be managed in a, quote, reasonable period of time, often defined as a year. Low or green risks need to be monitored, but do not require additional remediation. After creation of the initial risk assessment, it is necessary to implement and document the remaining safeguards. Over time, this will reduce the HIPAA risk, as defined by the federal government, to an acceptable level. The procedure for creating policy safeguards is described in video 3. After implementing and documenting the initial set of safeguards, view video 4 on risk assessment. This will provide instruction on updating the risk assessment as additional safeguards are created. At this point, your risk assessment should resemble that shown. All the immediate risks have been remediated. The yellow risks must be remediated in a, quote, reasonable period of time, unquote. To show reasonable diligence, it's necessary to complete at least one safeguard every quarter. The next step is to create policies to use for security awareness training. Lack of security awareness training is one of the main 3 reasons for HIPAA audit failures. If you choose an outside vendor for security awareness training, the training may not be consistent with your policies. This can lead to confusion and compliance issues. The implementation of security awareness training dramatically improves overall risk scores. It is difficult to implement safeguards without training. Creating and implementing the remaining moderate safeguards will generate an acceptable risk assessment showing full compliance with the reasonable and appropriate risk management standards for HIPAA as prescribed by the National Institute of Standards and Technology. The revised risk assessment may be updated at any time. After achieving full compliance, it is necessary to maintain that state. Many safeguards must be updated quarterly or annually. After updating safeguards, it is good practice to create a new risk assessment, preferably on a quarterly basis. New safeguards are periodically required by Health and Human Services under HIPAA. These are automatically integrated into the risk assessment process. It is important to maintain the regular cycle of updating the risk assessment, updating safeguards, updating the security awareness training, and repeating as needed. For more information, contact your testing manager or one of the individuals shown on this slide. Thank you for viewing our tutorial.